83,000 people displaced for luxury condos. See the failed law being used as a legal weapon to destroy affordable housing.
That is a staggering number to kick things off
It
with.
really is. Welcome to today's deep dive, everyone. We are jumping right into a topic that honestly, it fundamentally shapes the physical reality of the cities you live in.
Yeah, quite literally.
Today, we are decoding how a modest 1985 housing law morphed into this industrialized engine for gentrification in places like Los Angeles and San Francisco.
Right.
And we've got a great stack of sources for you today. We're pulling from an article by the Anti-Eviction Mapping Project and the Coalition for Economic Survival. Plus, we have these really fascinating statutory protection notes from a 33-year real estate veteran.
Those notes are incredibly insightful, actually.
They totally are. So the mission today is to understand how this law is being weaponized and, more importantly, look at the highly specific, cleverly designed legal deterrents that advocates and tenants are using to, throw sand in the gears of that gentrification machine.
Which is where it gets really interesting.
Okay, let's unpack this. Where does the timeline actually begin?
Well, before we hit the timeline, let's just set our parameters for you listening. Housing policy, particularly in California, is this inherently volatile, politically charged arena.
To put it mildly, yeah.
Exactly. I mean, you have fierce advocates for property rights on one side, and then equally fierce advocates for tenant protections on the other.
Right.
So our objective today isn't to pick a side or, endorse a political ideology. We are looking at this strictly as a study in systemic mechanics.
Just following the data and the rules.
Precisely. We want to understand how the rules of the game were originally written, how developers are leveraging those exact same rules today, and what the raw data tells us about the outcome on the ground.
So let's look at those original rules. The legislation at the center of all of this is called the Ellis Act.
Right, the Ellis Act.
And it was passed in 1985, championed by a Republican state senator named James Ellis. And if you look at the intent back in the mid-'80s, it was essentially designed as a pressure release valve for small business owners.
Yes, exactly. It was written with what we call mom and pop landlords in mind.
Okay, give me an example of that.
So imagine a retired couple who owns a duplex or maybe a small 4-unit building. And for whatever reason, maybe they're aging, maybe property taxes are just too high, or they just don't want the stress of being a landlord anymore.
Sure, they just want out.
Right. They want to stop renting out their property. The Ellis Act was created to give those small independent owners a legal definitive pathway to just exit the rental business.
Make a clean break.
Exactly. It allowed them to evict their tenants, not to replace them with higher paying tenants, but to genuinely close up shop and pull the property off the rental market entirely.
Wait, I need to stop you there because this is where my confusion starts with this whole thing.
Okay, sure.
If a city like Los Angeles or San Francisco has strict local rent control laws protecting tenants from being evicted without a just cause, how does a state law from 1985 just automatically override those local protections? I mean, how is that legally allowed?
That is the crucial structural tension at play here. In California, state law generally supersedes local municipal law.
Ah, okay.
Yeah. The state legislature decided that no local government could force an individual to stay in the business of being a landlord against their will. That was deemed a fundamental overreach.
Because it's their property.
Right. So the Ellis Act essentially trumps local rent control ordinances. If an owner files the paperwork and proves they are permanently withdrawing the units from the market, local rent control cannot stop the eviction.
Wow. Okay, so that makes sense on paper for a struggling retired couple, right? But modern reality is completely different universe.
Oh, completely different.
Today, the sources show this law is almost exclusively utilized by massive corporate landlords, institutional investors, and, luxury developers.
Yeah, they aren't trying to quietly retire to Florida.
Exactly. They're using this 1985 law to mass evict tenants, bulldoze or gut rent-controlled affordable housing, and build high-end luxury condos or boutique hotels on the empty dirt.
It's a massive shift in usage.
It's like a rule in a board game, meant to help a struggling player safely bow out. But decades later, the wealthiest players have figured out how to exploit that exact same rule to wipe out the board and build expensive hotels on every single property.
That board game analogy hits the nail on the head, honestly, because it highlights this shift in the financial mechanics. What's fascinating here is that the words of the Ellis Act haven't radically changed since 1985.
But the economics have.
Completely transformed. If you are an institutional developer looking at San Francisco or LA today, Older, rent-controlled buildings are highly attractive targets.
Why? Why target those specifically?
Because the building itself isn't what's valuable, it's the land underneath it. But as long as tenants are living there paying below market rent, that land is locked up.
Because nobody wants to buy a property that isn't generating maximum revenue, right?
Right. So the Ellis Act becomes the skeleton key. A corporate entity buys the rent-controlled building, invokes the Ellis Act by claiming they are, quote, going out of the rental business, evicts everyone, and suddenly that locked-up dirt is entirely theirs.
Theirs to redevelop into a multi-million-dollar luxury asset.
Exactly. The law shifted from a localized exit strategy to an industrialized wealth generator.
And the human cost of that wealth generation is just staggering. I mean, the statistics from our sources are incredibly jarring.
Yeah, let's look at those numbers.
Let's look at Los Angeles first. Between 2001 and 2023, there were 29,940 Ellis Act evictions filed.
Wow.
And that process forced roughly 83,832 tenants out of their homes. We are talking about the complete erasure of nearly 30,000 affordable units in a single city.
In just over 2 decades.
Yeah, and San Francisco is seeing the exact same trend. Between 1994 and 2022, they recorded 5,549 evictions, affecting well over 11,000 tenants.
To really grasp the gravity of those numbers, we need to look at the systemic ripple effects. We are witnessing an ecosystem collapse in these neighborhoods.
How do you mean?
Well, when a corporate landlord uses the Ellis Act to clear a rent-controlled building, those affordable units vanish permanently. They are almost never replaced with new affordable housing.
Right, they become luxury condos.
Exactly. So a displaced tenant isn't simply looking for a comparable apartment a few blocks away. They are suddenly thrust into a modern, hyperinflated market, where rent might be 2 or 3 times what they were previously paying.
And if they can't afford a 300% rent increase overnight, they're either pushed completely out of the city or pushed onto the street.
Yeah.
I mean, the sources draw a direct, measurable line between the escalating use of this law and the visible intensification of the homelessness crisis.
There absolutely is a line. And when we zoom in from the macro data of 83,000 people down to the actual neighborhood level, the destabilization becomes incredibly vivid.
Right. What does this actually look like on the ground for an average family or senior citizen?
Think about older adults and individuals with disabilities. For them, a localized environment isn't just convenient, it's a critical lifeline.
Oh, for sure.
Displacement severs their entire support network in an afternoon. It means suddenly losing geographical proximity to their trusted caregiver.
Or their doctors.
Right. It means they can no longer walk to the specialized doctors they've seen for a decade, or easily navigate the pharmacy and grocery store they rely on.
Yeah.
It effectively strips away their independence.
And that brings up the impact on families, too.
Yeah, definitely.
Because if you're raising kids and get hit with an Ellis eviction in, say, November or February, that derails the entire academic year.
Completely derails it.
You are forced to pull your kids out of their school mid-semester. They lose their teachers, their peer groups, their extracurriculars, and because you likely can't afford anything nearby, you're moving further away from the urban center.
Which creates a whole new set of problems.
Exactly. Suddenly, your commute to work doubles, you are farther from reliable public transit, and your entire household infrastructure is just fractured.
It creates a cascade of instability, and it really explains why displaced tenants are often forced entirely out of their state, completely uprooting their generational ties to a region.
So we have this pretty grim picture of a legal loophole acting as a bulldozer. But the narrative takes a really fascinating turn here, because the massive scale of this displacement is directly fueling how people are pushing back.
Yeah, it's not totally hopeless.
No, not at all. This isn't just a story of inevitable corporate victory. Have you seen the details on the Douglas Emmett case in our sources?
Oh, the situation at Barrington Plaza? That is a monumental precedent.
It really is. Douglas Emmett is a massive corporate landlord based in Santa Monica. And in May of 2023, they decided to deploy the Ellis Act to evict tenants from more than 570 rent-controlled apartments at Barrington Plaza in Los Angeles.
Over 500 units at once.
Over 500. The sheer audacity of that scale is wild. But the tenants didn't just pack boxes and leave. Partnering with the Coalition for Economic Survival and the AIDS Healthcare Foundation, they actually sued the landlord.
And they won. Yeah.
Yes. In June 2024, they actually won. They legally blocked the eviction of a massive residential community.
Which is a critical inflection point, I think, because it proves the Ellis Act is not an impenetrable magical shield for developers. It has vulnerabilities.
And here's where it gets really interesting. Fighting a massive corporate lawsuit in court is exhausting, and most buildings obviously don't have the resources of Barrington Plaza.
No, they don't.
But advocates don't always have to rely on giant lawsuits. There's an entire playbook of statutory protections, actual tripwires built into the law over the years, designed to make the Ellis Act less financially attractive to corporate flippers.
Yeah, these are brilliant.
We have detailed notes from a 33-year real estate veteran breaking down exactly how these deterrents work. So let's break down the mechanics of these four major tripwires.
I'd be glad to. The first major defensive mechanism is the condo ban.
The condo ban.
Right. So if a developer utilizes the Ellis Act to clear out a rental building, severe restrictions are immediately placed on the future of that property. One of the most stringent is that the building is legally prohibited from being converted into condominiums.
Okay, let's unpack why that actually matters to a developer. I mean, if I buy a building and empty it, why do I care if I can't make condos?
Because you are cutting off the fastest, most lucrative avenue for quick liquidity.
Ah, the quick flip.
Exactly. Developers often rely on short-term, high-interest loans to purchase these properties. Their goal is to acquire the building, clear it, subdivide it into individual luxury condos, and sell them off as fast as possible to pay back their lenders and book a massive profit.
Right, that makes sense.
By banning condo conversions, the law forces the developer to hold onto the entire property. It completely wrecks the business model of a quick, profitable flip.
It traps them with the asset. That is incredibly clever. Now, the second protection is arguably the most powerful one on the books, the 5-year freeze.
Yes, the 5-year freeze.
Let's say a developer evicts everyone, officially claiming they are exiting the rental business. But a year or two later, they change their mind and decide to put the property back on the rental market.
Which happens.
Right. This rule dictates that they must first offer the unit back to the original tenant. But here's the kicker. If the original tenant can't be found and they rent to a brand new tenant, that new tenant pays the exact same rent price as the old tenant for the first 5 years.
It acts as an absolute financial timeout.
Right. Because the entire corporate motivation for using the Ellis Act is to magically reset the property's price tag overnight.
Exactly.
They want to evict someone paying $1,200 a month so they can immediately charge a new tech worker $4,000 a month. But the 5-year freeze says if you come back to the rental market, you come back at the 1998 price point.
Yeah, and a developer looking to boost their quarterly earnings cannot wait 5 years for a return on investment. It really neutralizes the incentive to fake an exit from the market.
It's basically weaponizing time against institutional capital.
That is a great way to put it. And that brings us to the third layer of protection, which focuses on vulnerable demographics.
Like seniors.
Right. If a tenant is a senior citizen, or if they have a recognized disability, the law grants them an automatic 1-year extension before the eviction can be enforced.
Which obviously gives them a crucial window to find specialized housing and carefully transfer their medical networks. But how does that affect the developer on the other side?
It acts as a massive financial anchor. Again, real estate development relies heavily on leveraged debt and tight construction schedules.
Time is money.
Exactly.
Yeah.
If a developer buys a 20-unit building and even 1 or 2 of those tenants qualify for the senior or disabled extension, the developer cannot demolish the building or begin major renovations for an entire year.
Wow.
So for 12 full months, the developer is forced to pay exorbitant holding costs, property taxes, insurance, loan interest on a building that is sitting 90% empty and generating almost zero revenue.
That is wild.
That 1-year extension can single-handedly destroy the profit margin of a multi-million-dollar development project. It makes targeting buildings with elderly populations incredibly risky for investors.
So the bureaucracy basically becomes the defense.
Precisely.
And the fourth protection is perhaps the most hyper-targeted one I've ever seen. Seasonal protections.
Oh, this one is fascinating.
Under these rules, if a tenant is a teacher or if the household includes any children under the age of 18, they cannot be evicted during the school year. They can only be forced out during the summer months.
It's a fascinating piece of legislation because it forces the aggressive timeline of corporate development to bow completely to the rhythm of the local academic calendar.
Yeah, it really does.
It structurally acknowledges the exact destabilization we discussed earlier. It prevents that mid-year disruption of a child's education and social development. And from the developer's perspective, it injects yet another uncontrollable scheduling variable into their business plan.
When you lay all four of these out, the condo ban, the 5-year freeze, the senior extensions, the summer-only evictions, it really paints a stark contrast.
It really does.
On one side, you have the sheer financial gravity of a multimillion-dollar luxury development boom. But the primary defense against it isn't always a massive, sweeping, systemic overhaul. It relies on these highly specific, hyper-targeted statutory tripwires.
Yeah, little roadblocks.
Right. The goal isn't necessarily to beat the developer in a philosophical debate. The goal is to make the bureaucratic headache of evicting people so expensive and time-consuming that it simply isn't worth the financial reward.
It is an asymmetrical defense strategy, really. The advocates are using the friction of time and compliance to fight back against raw capital.
But that leads us directly to the elephant in the room. We have Larry Gross, the executive director of the Coalition for Economic Survival, going on record in the sources calling the Ellis Act a failed housing policy.
Yeah, he doesn't mince words.
No, he doesn't. And you have to wonder, if a policy has failed so spectacularly that the state has had to engineer this labyrinth of complicated tripwires just to keep it from actively destroying communities, why doesn't the state legislature simply repeal the law entirely?
Because repealing it strikes at the absolute core of the philosophical tension we mentioned at the start of this deep dive.
Yeah.
If we connect this to the bigger picture, California housing policy is locked in a decades-old, grinding standoff balancing tenant protections against property rights.
Right.
Repealing the Ellis Act outright is viewed by property advocates as a fundamental infringement on constitutional ownership. Their argument is essentially, if you buy a car, you are allowed to park it in your garage and never drive it right.
Sure.
So shouldn't a property owner have the ultimate right to decide what to do with their own land? If you own a building, shouldn't you be allowed to permanently stop renting it out?
The argument being that the state shouldn't be able to force you into labor as a landlord.
Correct. And that core philosophical argument makes any attempt at a full repeal a political minefield.
And beyond the philosophy, we have to look at the raw mechanics of political funding, too.
Absolutely.
Various housing activists have proposed incremental reforms over the years to close the loopholes. They've suggested requiring an owner to hold a property for a minimum number of years before they can invoke the act, or restricting repeat use by the same corporate entity.
Or demanding that developers replace every affordable unit they destroy on a strict one-for-one basis.
Exactly. But all of these efforts continually stall out in the legislature.
And if we look at the data regarding political contributions, the gridlock becomes much easier to understand.
It really does. The sources cite a 2021 investigation that highlighted the sheer financial influence of the real estate industry in blocking these reforms. The investigation tracked donations from the California Apartment Association, which is a major lobbying group for property owners.
And what do they find?
They found that the group had donated to state and local politicians in 51 out of California's 58 counties.
51 out of 58.
Yeah.
The political machinery is heavily funded, which creates a massive wall of resistance against even incremental common sense reforms. But ultimately, it all loops back to the core economic dynamic. In high-demand markets like Los Angeles and San Francisco, the financial returns for converting an aging, rent-controlled building into a brand-new luxury complex remain astronomically high.
The profit margins are enormous.
Exactly. As long as those financial incentives exist, the real estate industry will aggressively fund opposition to any legislation that threatens that business model. The financial incentive to exploit the 1985 loophole simply outpaces the political will to close it.
So what does this all mean for you listening today? Let's recap the journey we've been on.
Sounds good.
We started by examining the mechanics of a 1985 law, the Ellis Act, which was originally drafted as a quiet, reasonable exit door for struggling mom-and-pop landlords.
Right.
But over the last few decades, we've seen how corporate giants engineered that small exit door into a superhighway for urban displacement, utilizing the law to wipe out nearly 30,000 affordable units in Los Angeles alone, displacing tens of thousands of people to make room for luxury development.
Yeah, it's heavy stuff.
It is. Yet we've also seen that the fight on the ground is incredibly dynamic. Advocates aren't just sitting by, they're utilizing a very specific, highly strategic playbook of statutory protections.
Things like the summer-only evictions to protect students, bans on lucrative condo conversions, and those 5-year price freezes.
Exactly, to introduce massive financial friction and throw sand in the gears of the gentrification machine.
And understanding that friction is exactly why you should care about this topic, regardless of whether you rent your apartment, own your home, or are just living your day-to-day life in a community.
Yeah.
The mechanics of the Ellis Act perfectly demonstrate how abstract, bureaucratic legal frameworks dictate the physical, brick-and-mortar reality of our cities. These laws dictate who gets to live in your neighborhood, who can afford to work in your local schools, grocery stores, or hospitals.
So true.
And they directly impact the visible homelessness crisis we navigate on our streets every day.
It proves that a city's landscape isn't just shaped by architects and construction crews. It is actively sculpted by how lawyers and politicians interpret a 40-year-old document.
That is exactly right. And I want to leave you with a final thought to mull over as you look at your own city skyline.
Let's hear it.
We've seen that right now, the primary defense against losing affordable housing relies on highly specific, reactive legal tripwires that just try to slow developers down. It raises a fascinating, perhaps unsettling question for you to explore on your own.
Okay.
If the massive financial incentives for luxury development continue to outpace the penalties, what happens when the tension between property rights and tenant protections finally reaches a breaking point where no everyday workers can actually afford to live in the cities they serve?
Wow, that is a complex, deeply necessary question to ponder as we consider the future of urban life. Thank you so much for joining us on this deep dive into the hidden mechanics of housing, loopholes, and displacement. Keep asking questions, keep looking past the headlines, and we will catch you on the next deep dive.